any democracy. A change in the presidency signals the immediate resignation or replacement of these political appointees. Not so with the rest of civil service, whose tenure is protected against the vagaries of politics. This is also the reason why civil servants do not and should not participate in active politics, as they remain apolitical. It was also alleged that the third respondent gave the donations to internally displaced persons, but I found, looking at the affidavits and looking at the fact that the assistance to the internally displaced persons was in line with the work plan of government with the budget approval by Parliament in the previous financial year, which had no relation to the election. I find that the petitioner's allegations on bribery, intimidation, and undue influence are not proven. Now, I then have analyzed very carefully all the affidavit evidence. The affidavit evidence of the petitioner and the affidavit evidence of all the respondents. It's coming to over 100 pages. I would not wish to read all those pages. And in fact, having listened very carefully to my senior brother, Justice J.B. Ojwang, it is clear that we have made the same analysis and the same findings on those affidavits, and therefore, again, I will not read them, but I will leave you to look at them. Only my conclusion will be, having looked at all affidavits, is that I find that the petitioner in most of the allegations made did not discharge the onus of proof in them. Most of the allegations are bare, they're uncorroborated. The burden did not shift to the respondent to counter the allegations, as they bore no reinforcement through cogent evidence. In the instances where the petitioners did discharge the burden, I find that the respondents sufficiently supplied cogent evidence in rebuttal. On the other hand, where the respondents admitted the allegations, such as those of administrative errors, credible evidence was supplied to prove that these said errors did not materially affect the results, and they were not in favor of any particular candidate. So that is my conclusion on the affidavit evidence. I'd like to move on to an important issue, which is what I am calling the orders on access to information. The majority call it the orders on scrutiny. I prefer to use the language of the orders. It is orders on access to information. By a ruling delivered on 28 August 2017, this court considered a notice of motion application dated 25th August, seeking a number of orders. And those orders were read out by my brother, Justice Lenaola. I will not go through them. You are also, as parties, aware what the prayers were and what the orders were. The anchor of this application was that the electronic system of transmission had been deliberately compromised in a manner not intended by law so as to interfere with and affect the result of the presidential election. It was also contended that the election results from individual polling stations were not verifiable. Further, that 395,510 rejected or spoiled votes were unaccounted for, and that the KIMS system was designed only to transmit the results if the data entered was accompanied by an image of prescribed form. In the analysis of the ruling that we made on this application, the court summarized the prayers sought by the petitioner in the application to three limbs. One, access to information relating to hardware and software used in the conduct of the presidential election and particularly transmission of results. 2, access and scrutiny of certified copies, forms 34A, 34B, 34C, and leave to file further affidavits. Now, in regard to prayer number 2, which was access to and scrutiny of certified copies of Form 34A, B, and C, the court determined that the petitioners had signaled their intention to seek scrutiny of all rejected and votes, the returns of the presidential election votes, including but not limited to Form 34A, B, and C. And the first and second respondents said that, they said that there's an issue of the security of the system, of the transition. Also, they had an issue of the time. And within our ruling, the court was cognizant of the security system concerns raised by the first and second respondents, particularly the absolute confidentiality of passwords and usernames, the location of servers, the identity of password holders, the IP addresses and software running applications, among others. Therefore, none of those requests relating to those specifics were granted. I think it is important for us to be clear what was prayed for and what was granted. The court also disallowed prayer 3A, where the petitioners were seeking direct, unfettered access to relevant persons and systems at Saffron, being cognizant to jurisdictional difficulties of granting access to an entity based in France that was not a party to these proceedings. So that one we disallowed. Having evaluated the evidence and analyzed the arguments by counsel, this court made the following orders: distinct and modified from the prayers originally sought by the petitioners in the application. And this is what we said in paragraph 72. Having so held, the final orders we make are that the petitioners, as well as the third respondent, shall be granted a read-only access, which includes copying in brackets, if necessary, to 1, information relating to the number of servers in the exclusive possession of the first respondent. 2, firewalls without disclosure of the software version. C, operating systems without releasing the software version. D, password policy. E, password matrix. F, system user types and level of access. G, IEBC election technology system redundancy plan comprising its business continuity plan and disaster recovery plan. H, certified copies of certificates of penetration tests conducted by IEBC prior and during the election. Certified copies of all reports prepared pursuant to Regulation 10 of Elections Technologies Regulations. Certified copies of certificates by professionals prepared pursuant to Regulation 10.2. Specific GPRS locations of each KIMS kit during presidential election for the period between 8th August and 11th August. Certified list of KIMS kits. Polling station allocation for each KIMS kit. Technical partnership agreements. Login trails of users and equipment into the IBC servers. Login trails of users and equipment into KIMS database management systems. Administrative access log into IBC public portal between 5th August to date. Information, and we said the information listed MNO shall be issued in soft copy to the petitioners. Let me repeat this. The information listed in M, N, and O shall be issued in soft copy to petitioners and the third respondent. Q, certified photocopies of the original forms 34 A's, B's, C's prepared and obtained from the polling stations by presiding officers. Then forms 34A, B, C from all 4 40,800 polling stations. 40,800 was what was requested for, although there are actually more. Lastly, scanned, transmitted copies of all Form 34As and Bs. We also made the orders that the registrar of this court, assisted by a number of judicial officers, as she may determine, shall supervise, not shall conduct, shall supervise access to the certified copies of the original Form 34A and B by the petitioners, the third respondents, at such venue that she shall determine in consultation with the parties, and that the report would be brought and parties would be at liberty to submit at the end of the hearing. We said specifically that the exercises were limited to the areas complained of in the affidavit of Norman Magaya, Omar Yusuf Mohammed, Dr. Nyagasi Oduo, and that we would appoint an IT officer with 2 experts to also supervise the access to the technology. Now, the court then set out the parameters for the exercise and mandated the registrar to exercise to supervise the access to the certified copies of the forms and file the report by 5 p.m. Tuesday. In addition, our ICT officer with our experts were tasked to supervise access on technology and to file the report. Now, the submissions for the parties were as follows from that exercise. At the end of the exercise, the parties were each allowed to submit on reports filed by the ICT experts and the registrar. Counsel for the petitioner, Mr. Orengo, referred the court to paragraph 13 of the report, where the number of forms 34A, 34B, 34C availed by the first respondent had been indicated. Counsel pointed out some of the remarks that had been made by the registrar on the process in the report. 1, Form 34As for Mandera West were not among the forms submitted. B, they were ineligible forms, not indicated which. C, certain Forms 38 appeared to have duplicates. D, certain Form 34As and 34Bs appeared to be carbon copies. E, certain Form 34As and 34Bs appeared to have been photocopies. F, some of the forms were neither signed or stamped. Counsel Orengo took issue with forms that did not bear any security features or serialization. He cautioned that certain Form 34Bs were neither signed by the returning officer nor by agents. He said 56 forms did not have a watermark, 31 forms did not have serial numbers, 32 forms were not signed by the agents, and 189 did not have handover notes. Counsel Orengo expressed dissatisfaction with non-compliance with a segment of the orders of the court on ICT access. He also contended that most of the forms were not in standardized format. On the other hand, Mr. Moite, counsel for the first respondent, commenced by urging the court to compare the contents of the registrar's reports using the forms that were deposited in court pursuant to Section 12 of the Supreme Court Act. He also urged that, contrary to the allegations made by the counsel for petitioners, the statutory forms matched the format of the regulations, and he stated that although the security features were not a legal requirement for the forms, the Commission, out of an abundance of caution, designed security features for them. Counsel also submitted that the first respondent had complied with all the orders of the court, including availing soft copy access of the logs to the petitioners who declined to accept them. This was also indicated in the expert's report. The petitioners wanted to have the login trails loaded from the servers as they observed. It was Counsel Muite's submission that with regard to some of the orders, the limited time available to conduct the exercise precluded its completion because of the time difference between Europe and the United States, where the principal service provider, Saffron, and the company subcontracted by Saffron resided. Counsel Muite revisited the issue of transmission, clarified the difference between data that was broadcast on the screen and results in the portal. He elaborated following the decision of Maina Kiai, the second respondent had to reconfigure the way it displayed information being sent from the constituency and explained that sometimes the data arrived without the accompanying image, hence the discrepancy. He urged the first respondent, he however urged that the first respondent took every measure to align its processes to the directions of the court, which directions came literally on the eve of the elections. Justice Lenaola queried the lack of a serial number on the statutory Form 34B to declare the results of Nyali constituency in Mombasa County. Mr. Ngatia, counsel for the third respondent, commenced his submissions with reference to Kisauni constituency. He noted that although it had been indicated in the report, the registrar's report, that Form 34B was not signed by the returning officer, the form in his possession from his agents indicated that the same was indeed signed, and he urged the court to compare the report on Nyali constituency with the Form 34B deposited in the court under Section 12 of the Supreme Court Act. Counsel indicated that in some areas, lapses were occasioned by difficulties such as broken down printers, as was the case in Isiolo South. And counsel also submitted that the numbers in these forms were not challenged. The numbers, as in the results, were not challenged, and there was no discrepancy between the entry in forms for 34A and 34B. Now, after the bench retired to access the evidence and to make findings on this exercise supervised by the registrar and our IT experts, I myself undertook a comparison of the complaints and allegations made by the petitioner in both reports with Form 34A and Form 34B that had been submitted to the court under Section 12 of the Supreme Court Act. Those forms, the statutory requirement to submit certified copies of the original forms under Section 12 of the Supreme Court Act meant that the IEBC had filed evidence under statute before this court, which we could look at. And therefore, I did. And in doing so, I made a number of interesting findings. For example, on the query raised by Justice Lenaola on the lack of a serial number on the statutory Form 34B, used to declare the Nyali constituency, Mombasa County, I pulled the form out of the bundle of certified forms provided to the court and noted the following. That form had 4 pages that bears serial numbers PR 00100425, PR 00100426, PR 00047, PR 0010048. I also found it is stamped. I also found that the name and identity of the constituency returning officer is indicated. I also found that it is signed by the returning officer. I also found that it is signed by the agents for both Uhuru Kenyatta and Raila Odinga. I found that the form was printed in landscape as opposed to portrait, but the serial numbers were there at the bottom left corner. As regards the complaint regarding Kisauni, I also took the liberty to retrieve the form from the evidence deposited in the court. And I found the form has 4 pages bearing serial numbers PR 001003 to 7, PR 001003 to 8, PR 001003 to 9, PR 001003 to 10. I found that the Form 34B is signed by the returning officer and it is stamped, and in fact it is signed by 6 agents. The handover section has also been filled. Regarding Likoni, which was also flagged by counsel as marked as being unsigned, I also retrieved the certified copy of Form 34B and found it is signed by the returning officer, whose name and ID are indicated. It bears a serial number, it has an anti-copying feature, and it is stamped, and it was signed by 8 agents. Thus, I was able as a judge, sitting on an election cause, able to verify the issue in question. Regarding the ICT report, Council submitted that the third respondent accepted the pre-downloaded log trails as compliance with the orders of the court. It was submitted that according to the conclusion in the ICT report, the third respondent submitted that the first respondent indicated that a read-only access would be available only at 11 a.m. on 29th August. However, petitioners asked for administrative rights which were beyond the purview of the order of the court. In summary, and according to the ICT report, information relating to the number of services was provided. Information regarding firewalls without disclosure of software was not fully provided because disclosing internal and external firewall configurations would affect the security of the systems. However, schematic diagram and hardware models were provided. Operating systems without software versions was supplied. Password policy was provided. Password matrix was provided. System user types and level of access was provided. Disaster recovery plan was provided. Certified copies of penetration tests was provided together with certificates. GPS, not GPRS, but GPS locations for polling stations was provided. The specific GPRS locations for each KIMS kit was not provided. Certificate list of all KIMS procured was provided. Polling station allocation for each kit was provided. Technical partnership agreement was provided. Preloaded log trails was provided but rejected by the petitioners. In conclusion, the report indicated that the first respondent faced a number of challenges in complying with the server read-only access, including setup of the VPN tunnel to the server, connectivity challenges when accessing the cloud, security protection measures that needed to be upheld for elections. I depart from the majority here. I am satisfied that the terms of the court's orders were met to the best extent possible. Although the parties seem to have differed on the interpretation of the orders, I find that they are very clear and free from misconstruction. The orders were of access to information and read-only access, which included copying if necessary. The court orders were very clear. They were also very distinct from the prayers originally sought in the application. The court took the concerns of all the parties into consideration before making a determination on the application. Any interference into the any inference into the intent or assumed order of the court cannot therefore be left to flourish. For avoidance of doubt, I am in agreement with the Constitutional Court of South Africa and Firestone, South Africa versus Ginkuro on the interpretation of court orders, which says, on interpreting the court orders, the authority tells us the basic principles applicable to construing documents also apply to the construction of the court's judgment or order. The court's intention is to be ascertained primarily from the language of the judgment or order as construed accordingly to the usual well-known rules. In the case of a document, the judgment or order and the court's reasons for giving it must be read as a whole in order to assert its intention. If on such a reading, the meaning of the judgment or order is clear and unambiguous, no extrinsic fact or evidence is admissible to contradict, vary, qualify, or supplement it. End quote. On this, the first respondent expressed real threats with regard to exposing the inner workings of their technology to external supervision or influence owing to numerous considerations of a public nature. We must acknowledge that the Commission is an independent constitutional body with powers to regulate vital procedures such as the deployment of technology in elections. Although the petitioners prayed for unfettered access into the servers, The court, in consideration of the security concerns and in line with principles of justice and equity, did not grant this, but granted only specific limited orders to information, which, in my opinion, were met. For the avoidance of doubt, this court did not give orders for the petitioner to access the servers of the first respondent. What was given was the access to particular read-only information. The location of servers, the entry and penetration into servers were not part of the orders given. It would be dangerous to expose the Commission to any administrative incapacity in future elections or in the future. The court has a responsibility to preserve the working systems of the IEBC for future elections. I acknowledge and I approve the following reason of the Constitutional Court of South Africa in Electoral Commission versus Mhlophe and others. In this case, the Constitutional Electoral Commission of South Africa approached the Constitutional Court with prayers to condone certain shortcomings it had in the face of an approaching by-election. The Constitutional Court considered the remedies available, stating, I quote, "I have spelled out the difficult position in which the IEC finds itself. Ordinarily, it would be easy to dismiss its request on the basis that the situation in which it finds itself is of its own making. But the reality is, unlike litigation between private individuals, where a party's fault would affect it and it alone, here, if something were to go wrong, the implications are serious and likely consequences dire. To put it bluntly, the IEC would not be able to certify the voters' roll for want of 12.2 million addresses. Without a certified voters' roll, there can be no elections. In terms of Section 159 of the Constitution, it is obligatory that the elections must take place and must do so not later than the 16th of August 2016. Indeed, the need for regularity of elections in the Constitution's founding values underscores the importance of this obligation. Unsurprisingly, Section 19.2 provides that every citizen has the right to free and fair regular elections for any legislative body. A threat to the possibility of elections not taking place is a threat to our democracy ourselves. An order that does not extricate the IEC from the impossible situation it is may create a constitutional crisis affecting the rights to vote. We are bound by the Bill of Rights. We must be careful in as far as possible to prevent that from happening. We cannot, in a Pelagian manner, throw our hands in the air and say, if the crisis happens, so be it. The root cause is in the IEC, not us. The reality is facing us. What may we do, if anything? Consequently, I do not find that the first and second respondents were in any contempt of the court's orders, and also find no basis to nullify the presidential elections on basis of any information revealed or otherwise in the report. I find that the allegations of inconsistency in Form 34A and Form 34B is verifiable using the existing paper trail, which is also in possession of the petitioner, who also requested the court read a letter dated 23rd August, and the entire set of primary records was provided to the petitioner in scanned form by this court on the 24th of August 2017. Regarding the lack of security features on Form 34's A and B, it is imperative to first contextualize the exercise that gives rise to these conclusions. One, it was a party-led process and not a court-led process. If it met the proper guidelines for proper scrutiny, it would have been a court-led process. It was not. It was a party-led process supervised by a court official. Secondly, it was a technical process that is usually the preserve of an election court. Like I've said, scrutiny encompasses an examination of an entire election material related to the election, but this was not the case in this instance. Some of the findings are negated by reference to the statutory forms deposited by the court pursuant to Section 12 of the Supreme Court Act. I have given you some examples. I have even more I can give. It was submitted in the presence of it was submitted that the presence of one security feature is sufficient to insulate the statutory form from unauthorized reproduction. I find that this is a sufficient measure in the general scheme of other tools of verifications guaranteed by the Constitution and electoral law, including the ballots and other election materials. Finally, the presence of security features on the forms is not statutory or legal. It is statutory or legal on the ballot paper, but it is not statutory or legal on the form. It is administrative and therefore one of the components of verifications of the electoral process. That's all it is. Failure to have them on the forms is not fatal. The majority admits that the security features are not provided for under any legal provision. The basis for their determination is that there is no plausible explanation when Immaculate Kasait has indicated all forms 34A and 34B bore these features. The court, however, the majority, had the option to personally examine the original certified forms deposited in the registry, like I did, but they did not do so. As such, an order for nullification based on this exercise that was merely based on controvertible and speculative grounds and is well below the standards for nullifying an election, especially where other remedies such as an inspection of ballots exists, should never be given. The majority did not address themselves to any other evidence in arriving at their determination. Had they systematically analyzed the evidence, they would not have determined the election on a tangential issue whose determination could easily have been settled through reference by the court itself to the evidence deposited by the first respondent 48 hours after the filing of the petition. It is important to appreciate that the circumstances under which the first respondent was operating immediately before the elections, where they were dogged with court cases which slowed down their operations and their normal cohesive preparedness to conduct the elections, was hindered. Elections are public in nature. The actors and stakeholders involved in the electoral process ought to fully support the first respondent in the execution of its mandate. In instances of lapse, how is the court to apportion blame, particularly if instances of active distraction from duty, like court cases and other things by other actors and stakeholders, have occurred? How do you apportion blame? I now move to the evidence submitted under Section 12 of the Supreme Court Act. The material deposited by the Commission, pursuant to Section 12(2) of the Supreme Court Act, enables the essence of the Supreme Court to discharge its mandate as the final election verifying avenue. It is imperative to mention that the Commission fully complied within 48 hours of the petition being filed. They filed these documents in court. At the time of determining this matter, all the materials used to declare the results of the presidential election, including Form 34A and Form 34Bs, had been deposited at the Supreme Court Registry by the Commission. Like I said earlier, in furtherance of my duty as a judge hearing a matter falling under the exclusive original jurisdiction of this court, I have considered all the allegations in the pleadings and supported evidence thereof against this material. Following the exercise ordered by the court on the production of Form 34A and B, after which parties undertook a partial scrutiny, if that's what it can be called, of the forms, counsel for the respondents urged the court to consider the report in light of Form 34's A and B's that had been deposited in the court by the respondents as part of mandatory discovery under... Thank you very much. I think I'll use the bottle. Thank you. Following the exercise ordered by the court on the production of Forms 34A and 34B, after which the parties undertook a partial scrutiny of the forms, counsel for the respondents urged the court to consider the report in the light of Forms 34A and B, which had been deposited in the court by the respondents as part of the mandatory discovery under Section 12 of the Supreme Court Act. I have already analyzed the report based on the contents provided by the registrar and the ICT experts in the foregoing section. This section, however, follows the determination that an election court, as a final verifying agency, must employ the tools granted by the Constitution and electoral law to ensure that the ends of justice are met and that the right of the electorate to vote on the candidates to vie for any positions is protected from any illegal or irregular practice and election offense on the one hand or unfair exclusion of votes on the other. In the registrar's report, it was noted that 5 constituencies were in serious contention of want of form. The report indicated that the forms 34B in Kisauni, Nyali, Likoni, Mandera South, Isiolo South constituencies were not signed by the returning officer. That the Nyali constituency form 34B lacked a watermark. That the form B in Isiolo South was not signed by the party agents. The evidence deposited in court by the first and second respondents under Section 12 revealed that the disputed forms were proper in form and bore all the relevant features. The observations are summarized as follows. County, Kisauni, number of pages 4, serial numbers, I have listed them. Signed by the returning officer, yes. Stamped, yes. Signed by party agents, yes. Nyali, number of pages 4, serial numbers, I put them down. Was it signed by the returning officer? Yes. Was it stamped? Yes. Was it signed by party agents? Yes. Likoni, number of pages 3. There's 3 serial numbers. Was it signed by the returning officer? Yes. Was it stamped? Yes. Was it signed by party agents? Yes. Mandera South, a total of 2 pages. It had 1 serial number on 1 page. The other one is not legible. Was it signed by the returning officer? Yes. Was it stamped? Yes. Was it signed by party agents? Yes. Isiolo South had 2 forms. The serial numbers, I have put them here. They were clear serial numbers. Was it signed by the returning officer? Yes. Did it have an official IEBC stamp? Yes. Was it signed by party agents? Yes. So, compared to what the report that the registrar gave us, when it was compared with the certified original copies that the IEBC gave this court as evidence, then all those problems fell. There were no problems. That is what is meant by verification. You verify against the evidence. The legality of Forms 34A and 34B was also heavily contested by the petitioners and evidence adduced on the same. In the interest of justice, I set out to examine each of the forms that were disputed with, the ones which were disputed with particularity, in the detailed affidavit of Dr. Nyangasi Oduo in support of the petition and examined whether the forms met the test of verification set out in this judgment. My observations are as follows. There were 1,640 Form 34As and Form 34Bs that in total were disputed with particularity. There were 1,349 Forms 34A which were disputed with particularity. All 291 Forms 34B were also disputed. Now, what I have done is I have a table in which I have shown how I went through each form. The areas, I've noted the constituency code, the constituency, the number of pages of the form. I have noted the serial number. I have noted the barcode. I have noted whether it was stamped by IBC. I have noted whether or not it was signed by the returning officer. I have noted the names of the parties that had agents. I have also noted the specific name of the returning officer. So this is around, let me say around 75 pages. That is the extent of my exercise based on the complaints in the affidavit of Dr. Nyangasi Oduo. I want to give you some examples very quickly because I'm not going to read all of them. But let me give you some examples. For example, Dr. Nyangusi alleged at paragraph 140 that Form 34A of Kenten Primary School in Nakuru County was not signed by the presiding officer and the party agent. When I looked at the certified copies which were given to us, I found that this allegation is inaccurate. There is a Form 34A serial number PR285331 that was signed by the presiding officer, Alan O'Levy, and 9 party agents, 2 from JP, 1 ODM, 1 ANC, 1 CCM, 3 independent candidates, and 1 KANU. Dr. Nyagasi alleges in paragraph 143 that Form 34A of Kilingele Primary School in Kitui County was not signed by the presiding officer. When I undertook this exercise and I compared it to the forms, I found it is inaccurate and that there is a Form 34A serial number PR106099 which was signed by both the deputy presiding officer and the presiding officer, Grace Rael Munyao, and 4 agents. Dr. Nyangusi alleged in paragraph 174 that the Form 34A in Thome Primary School in Kitui County was not stamped by the presiding officer. I checked, and this is inaccurate. The said Form 34A serial number PR105427 was signed by the presiding officer, Martha Kioko, and 2 party agents, 1 JP, 1 Wiper. Dr. Nyagosi alleged in paragraph 44 that Form 34A of Musunji Primary School in Vihiga County showed a different result from the Vihiga County constituency Form 34B. When I checked the certified original forms, certified copies of the original forms submitted to us, I found this is inaccurate. The results captured in Form 34A serial number PR045264 were signed by presiding officer Sophie Momanyi and were the same as those indicated by Vihiga constituency returning officer Isaac Ruto in Form 34B serial number PR038231-8. Then another allegation was in paragraph 48, where Dr. Nyagasi said that Form 34A of Kinyanka Primary School in Mary County showed a different result from the Igembe South constituency Form 34B. When I checked against the certified copies of the original form, I found it is inaccurate. The results captured in Form 34A serial number PR062443 by presiding officer Phyllis Naitore Mbaya was the same as those indicated by Igembe South constituency returning officer Elijah Mugo in the Form 34B serial number PR01205114. You can see I don't want to take you through 75 pages of this, but this is just an example of how it is possible to verify what came out of the exercise and actually to displace some of the allegations that were made. My conclusion, therefore, is having looked at all the Forms 34A and 34B, the 290 constituencies, that's 290 and 1 diaspora, I'm satisfied that all the forms that were in dispute met the required threshold in form and content. And I've said the findings are summarized below. You will be able to have a copy of this when I finish. I want to now move to compliance. This is Section 83 of the Elections Act. Section 83 of the Elections Act stipulates, no election shall be declared to be void by reason of non-compliance with any written law relating to that election if it appears that the election was conducted in accordance with the principles laid down in the Constitution and in that written law, or that the non-compliance did not affect the result of the election. Before this court settled the meaning of Section 83, and we did settle the meaning of the Election Act in 2014, the Court of Appeal had dealt with its interpretation in several cases. First, they looked at the case of Dr. Thuo Mathenge versus Deritu Gachagua, where, in this case, the irregularity was with regard to misprinting the name of the running mate of the first appellant. The name of the running mate was misprinted as Jeffrey Kamau Kibuye instead of Jeffrey Gitonga Ndegwa. As a result of this, the appellant alleged that the supporters of the first appellant voted against him because they felt they had been misled. The Court of Appeal concurred with the trial court's findings and declined to nullify the election. The court held that the election was substantially in conformity with the law, and the error on the ballot paper did not affect the election result. The Court of Appeal reiterated that the election could not be nullified as Article 83 of the Elections Act prohibits an election from being declared a nullity on the grounds of non-compliance with any written law if it appears that the election was conducted in accordance with the law, or if there is non-compliance, the same did not affect the results. The Court of Appeal also, in James Omingo Magara versus Manson Nyamwea, also held that the courts will strive to preserve an election as being in accordance with the law, even where there have been significant breaches of official duties and election rules, provided that the results of the elections were unaffected. In its conclusion, in that case, the Court of Appeal referred to the binding decision of the Supreme Court in the Ryla 2013 case, in which the court held, since the election results reflected the electoral intent of the people, the court had a duty to uphold the same. In Peter Gishuki Kingara versus the IEBC, the Court of Appeal analyzed the evidence regarding errors that were admitted by the respondents in their pleadings and the second respondents during cross-examination. Based on these reasons, the Court of Appeal held that the totality of those irregularities which were unverifiable most probably affected the result, and consequently, they nullified the election. In Dickson Mwenda Gidinji versus Gitarao Peter Munya, which was later overturned in this court, the Court of Appeal in this case, the vote margin between the appellant and the first respondent was 3,436 votes. This, in accordance to the Court of Appeal, translated to 0.819% margin of the total votes cast, which was 423,247. The crux of this appeal was whether the errors and irregularities disclosed by the evidence on record materially affected the quantitative margin and the qualitative aspects of the Meru gubernatorial election. Counsel for the appellant provided extensive arguments on the application of the principles of the case in Morgan versus Simpson. The Court of Appeal also held as follows, quote, the margin between the winning and the losing candidate is a factor in determining whether the irregularity affected the results of the election. In deciding whether to annul an election, an important consideration is whether the number of impugned votes is sufficient to cast doubt on the true winner of the election, or whether the irregularities are such as to call into question the integrity of the electoral process. If the court is satisfied that because of the irregularities, the winner is in doubt, it would be unreasonable for the court not to annul elections. Before annulling an election based on irregularity, the magic number test has to be considered. This means that the contested or irregular votes cast, when set aside, must exceed the margin between the winner and the runner-up. If after an arithmetical calculation has been made and the returned candidate still maintains a lead over his nearest rival, the results of the elections have not been materially affected. Additionally, the Court of Appeal analyzed the qualitative and quantitative tests in order to determine whether non-compliance affected the result. It referred to two cases in which the Ugandan court and the Supreme Court in Kenya referred to as the qualitative and quantitative test. In the Ugandan case, Winnie Babihuga versus Masiko Winnie Kamuhangi, it was stated that the quantitative test is the most relevant, where the numbers and figures are in question, whereas the qualitative test is most suitable, where the quality of the entire electoral process is questioned. And the court has to determine whether or not the election was free and fair. The principle there was reiterated in this court in the case of Ali Hassan Joho versus Suleiman Said Shabal, where we said, quote, bearing in mind the nature of election petitions, the declared election results enumerated in the forms provided are quantitative and involve numerical composition. It would be safe to assume, therefore, that where a candidate was challenging the declared results of an election, a quantitative breakdown would be a key component in the cause. It must also be ascertainable who the winner and who the loser in an election are. From the foregoing, the Court of Appeal held that the trial judge in the High Court erred and misdirected himself in finding that a margin of 0.819%, which is less than 1%, could be described as wide. The Court of Appeal held that the margin of votes between the winner and the runner-up was statistically small, and if the trial judge adjustment due to proved errors and irregularities as disclosed in the evidence of DW10, the margin between the returned candidate and the runner-up would significantly impacted and the election result materially affected. Finally, the Court of Appeal, in the case of Moses Masika Wetangula versus Muskari Nazi Kombo, in this case, the appellant was declared the winner of the election after garnering 469 votes, whereas the runner-up, the first respondent, had garnered 125,853 votes. The trial court nullified the election on the ground that there were irregularities allegedly committed in the conduct of elections affected the results of the election. The Court of Appeal relied on RILA 2013 to the extent that the petition must prove that the non-compliance with the electoral law impugned the integrity of the election. The Court of Appeal